Thank you, Madam Deputy President. I rise to commend the disallowance motion moved by the Honourable John Ruddock. I also commend the Honourable Damien Tudor-Hope's suggestion that a new regulation that appropriately limits the scope and length of the regulation be drafted in a bipartisan way. Corruption is a scourge on good governance, trust in politicians, and in our parliamentary system. Those opposite are making strawman arguments that seek to politicise the real and reasonable concerns of the Honourable John Ruddock and the Honourable Rod Roberts and the opposition about incursions of privacy. They're principles that traditionally underpin our liberal democratic society. Uncovering unscrupulous and potentially illegal behaviour by public officials is an incredibly important duty. And let me be very clear that my argument does not denigrate the role or function of ICAC in undertaking that duty. But I do urge proportionality in giving any organisation such extraordinary powers for investigation, particularly powers unlimited by scope, as this regulatory change seeks to provide. What the Honourable John Ruddock's motion seeks to rectify is an overreach. If the material and investigation relates to a single matter, let that be specified in the regulation. The intent of the opposition's support of the disallowance motion does not argue the importance of investigation of a specific matter. However, that the Independent Commission Against Corruption may use illegally recorded material, that is, material obtained without consent by a third party, for a period of 27 months without limit to the scope of investigation is an astonishing use of executive power. This is a very serious matter to come before Parliament. The broad scope and lengthy effect of the changes are what make the Surveillance Devices Amendment ICAC Regulation 2023 so alarming. That the ICAC Chief Commissioner has apparently requested an exemption to use any illegally obtained content for any possible matter falls well outside the usual parameters that restrict use of such material. The matter of investigation into Michael McGurk has already been canvassed. If this regulation change had instead been bound by the scope of a particular investigation in an explained timeframe and passed through the Parliament, we would not be having the same conversation. But the government has chosen a different pathway. The actual effect of the regulatory change is not, as the Attorney-General and the Honourable John Graham has indicated, limited to a single investigation. This should cause all members to pause. Consider that this behaviour, recording a private conversation without consent, is illegal for a reason. As a community and a parliament, we have decided that recording people in private situations without their consent is not okay. Consent is one of the cornerstones of a civilised society. As the Honourable John Ruddock eloquently explained, the regulation overturns underpinning notions of privacy that are otherwise enshrined in law in various ways in liberal democracies around the world. Where covert recordings or materials are required in New South Wales, the police and ICAC can be empowered to conduct such investigations. Illegal recording is the kind of behaviour that begets illegal behaviour. It leads to blackmail, vigilante justice, psychological harm, a reduction in our safe spaces. It is an activity that carries a maximum 5-year jail sentence. Illegal recordings may also be considered inadmissible evidence in a court of law. It is important to reiterate this information because ICAC is seeking to hold itself outside of this law, to use the material obtained unlawfully to further its aims. Yet, in the case of the Surveillance Devices Amendment ICAC Regulation 2023, there is no clear aim, and this is the crux of the problem. Now, I don't believe that these are the intentions of ICAC, but these changes will necessarily indicate to some members of the public that recording people illegally is acceptable in the name of ICAC, no matter the possible reason, until the end of 2025. Without meaningful parameters on the circumstances in which illegal recordings may be viewed or listened to, there is a real risk of promoting vigilantism and unlawful behaviour. Because while the act of recording itself will remain illegal, individuals are still, of course, able to provide anonymous evidence to ICAC. It might be through encrypted messaging apps, email servers, or old-fashioned briefcases on the doorstep. A $55,000 fine may even be considered a worthwhile investment if the unlawful recording successfully destroys a rival's reputation. That the government is evidently willing to grant ICAC such powers without thorough explanation to the Parliament and to the public as to why these changes are necessary is concerning. This could have been the subject of a legislative rather than a regulatory amendment. Instead, it was submitted quietly to the House with no chance to consider, discuss or debate. I acknowledge that it could have gone through gazetted without any mention to Parliament, and I think it's interesting that the government is seeking to use that as a reason to explain its openness or provide a reason that we should be grateful for the government's bringing to Parliament this matter. But the regulation change is an open-ended proposition. What the government have told us is that the Chief Commissioner said the regulation change was in relation to a particular investigation. But again, this is not reflected in the actual regulation itself. And then, according to the media, the exemptions to use illegally obtained materials specifically relate to the investigation of Jean Nassif. If true, it is wrong that such information is given to the media by those with such knowledge, but that it is not shared with the Parliament or referred to specifically in law or regulation. I presume that ICAC was not the source of this now public information. It is a very serious problem if such blatant backgrounding occurs from the highest officers of government with the clear intention of obfuscating or misleading the public about the actual function of such a serious regulatory change. Let the regulation relate specifically to an investigation if that is its real intention, because a wider change comes at the expense of the public and civil rights. Rights to civil liberties are found throughout our legislative system rather than in a single document. In this case, the Surveillance Devices Act 2007 serves this function. The Legislation Review Committee, of which I am a member, recognised the need to clarify the effect of the legislation, as tabled this morning by the Honourable Cameron Murphy, and as amended at yesterday's meeting. The committee's most recent report specifically notes that, I quote, "the provisions are not worded so as to limit its application to any particular investigation." The committee decided to refer the matter back to Parliament because of questions about the regulation's incursions on human rights. And I once again acknowledge the very important work of the ICAC. However, such powers that it may be granted should not come at such a cost as to encourage secret, illegal recording and attempts at vigilante justice by people other than ICAC. An integrity body investigating matters by allowing, if not encouraging, unscrupulous means should always be cause for pause. The ends should not justify the means, where benefit from illegal behaviour is considered allowable without parameters. The Henry VIII power that gives the executive the power to bypass Parliament in decision-making is used generally for the function of nimble decision-making, but in this case, the use of the power transgresses its intended function. The substantial change to the nature of potential evidence, of signals about acceptable behaviour, if the ends may justify it, of implied rights to privacy are well beyond proportionate change. ICAC is tasked with investigating corruption, even outside the standard of criminality. They are already granted extraordinary powers to make findings from wide-ranging investigations. The question we have to ask ourselves is where changes to acceptable standards of behaviour and process can be made, what is the cost? Because privacy and rights are not going to defend themselves. It is up to us to carefully consider and make law that proportionately balances rights and responsibilities. When considering legislation and regulation in Parliament, we must always have regard for citizens and their rights first. This is why the disallowance motion is so important. Our state's constitution places people at the centre of our system of government. It is fundamentally important that we uphold this directive in our work. A change to regulation that allows the free use of illegally obtained information by ICAC on no particular matter for a period of 2.5 years should be an unacceptable incursion on citizens for any Liberal Democratic government. ICAC, like the police, should be encouraged to act lawfully and with integrity, and the request to amend regulations to lawfully consider potentially unlawfully recorded material is a testament to ICAC's integrity. Again, my argument does not denigrate the role of ICAC, but I urge proportionality in giving the organisation extraordinary powers for investigation, particularly unlimited by scope as these regulations are. ICAC has a job, like the police, and we allow government-approved activities to undertake those jobs. ICAC is already given investigative powers beyond the scope of ordinary investigation. Going further should be subject to scrutiny and limited tightly by scope and length, which the government's regulatory change does not do. For the good governance of New South Wales and respect for our citizens, I urge support for this disallowance motion.
Thank you.